Good. Okay. Kaitāia. Welcome back, everyone, after the break. We now have our second submitter. This is Ngāti Kura on behalf of Moana Kif. We have two pieces of evidence that we've received from you, but as you're not experts in that sense, and that's not a pejorative term, it means that you're allowed to present your evidence as you've submitted it. If you want something to read to us, we're more than happy for you to do that. Or how would you like to present your submission?
Can we make a correction?
Oh yes, you can do that.
We are here on behalf of whānau nui o Waiawa o Ngāti Kura. I think if we were to say we represent Ngāti Kura, just Ngāti Kura, we would get into trouble for that.
Okay, so let me record. So your
Te whānau nui o Waiawa o Ngāti Kura.
Now, I'll just explain. You'll see me tapping away here and others. We've actually got all the documents on our laptop, so I assure you I'm not watching cat videos on TikTok or updating my Facebook status. So, yeah, I'm just typing notes and looking at your evidence as we proceed.
I would also like, to request a correction that they are the sole experts on their culture.
Yes. Yes, okay. Well, we're in your hands, and so present your evidence as you see fit.
As I see fit, okay. Kia ora koutou. Ko whakarara te maunga, ko matauri te mohana, ko mātātua te waka, ko ngāpui te whare me te iwi, ko moana hau. I'm feeling like I just need to freestyle out of my mind. I know we've only been given a short time, so, and there seems to be a lot, so, yeah, out of my mind. This is a whanaunga, Vicky Monsell, and Andrea Milanovola, all the way actually from Croatia. She's spent 50 hours in a plane to be here, so very grateful for that support. So a lot of what we've been hearing this morning, of course, is about the plan changes and stuff. And for me, so much of that is so over my head. And, we've been sitting here listening to yes this and yes that, and feel like there's lots of ways that we fall through the cracks. I think even amongst all of these, everybody here, even the fact that we can't even identify who we are and why we're here sort of speaks a lot to the confusion. For me, my whakapapa, I whakapapa directly to Waiawa. My grandmother was born there in 1913. At that time, there might have been 8 or 10 living there. So we've had that connection. Well, I've actually, there will be 5 generations now, plus all the ones before, plus all the ones coming, that will be connected to that place. We've had since the 90s, I think 95, we've had a little bit of a rough ride with being a Māori incorporation and having land, our boundary neighbour, which is Kauri Cliffs at this point in time, but that's changed over the years. And it seems over the years we've had different disputes with a lot, I guess it started looking bad for us when we sold all of that Waiawa estate with 3 blankets and 6 spades. So, you know, that's how impactful. Well, it just continues, doesn't it? So now we're Matodi X's land is the boundary neighbour, and within that there are approximately 800 shareholders. They're shareholders, they're landowners, they're each and every individual in their own right is, so, you know, they say we've got one neighbour. Well, you don't have one neighbour, you have a lot. Yeah, and it's, you know, when we're talking about relationships and things, and everybody's lovely, you know, we do have a good, but especially today, I'm hearing that our relationship is a lot just for evidence for things like this. You know, I don't believe that there's been any real consultation. The beginning of my story coming into the council space was when, in 2022, when the building consent was granted for Kauri Cliffs to put the pavilion down on the beach. And as far as I could see on the maps and that was a significant natural area. And, you know, the footprint was supposed to be 25 square metres or something. And then they were given consent to build a 300 square metre pavilion plus and boat shed or something, way outside of everything. And, you know, we were so green we didn't have any submissions, or by the time we were putting in objections, it was pretty much too late. And that's when, and then the proposed plan stuff started coming out, and I thought, well, to my eyes, it looked like they were wanting to change a whole lot of rules to make it a whole lot easier for them to do what they wanted to do, which is fine, except for the fact that along with the pavilion, with their initial application was the kōrero about the 60 house residential development, and that terrified us all. The fact that this, I don't know if anyone's actually, well, there's lots of maps, but Waiawa it's an outstanding natural landscape. There's nothing there. It's pretty much just a windswept beach. We frequent it in the summertime. We can't access it during the winter because our track is not up for it. But yeah, so those were some of the concerns from the whānau, that it was just going to look totally different. If you have 60 houses, you have maybe 4 people, 6 floors of 24, to the impact of the extra people that would be able to access that. So that's on our resources, our moana, you know, that's sustained us, mairano, you know, the fishing, the kūtai, the pipi, the tuna in our awa, all of that. And I don't know that I know the impacts of what that would mean on our whenua. You know, we were being bombarded. We were getting resource consents for walking tracks, and we were getting plans for dams that are being built. And they were huge things happening right, bang, 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 one after another. And I read somewhere that, we stopped engaging, or we decided not to engage. This is the whānau, but I think it was more a case of we were overwhelmed. There was just so much information coming at us. Here's a great big master plan. You've got 2 weeks to look at it, understand it, comment on it. And to be honest, it was just beyond us. So, yeah, and the time frames, and when, I can struggle opening an email, let alone trying to navigate things like that. But anyway, so when the submissions were due to be put in, I worked with my sister and someone else, and that was a mad rush, and we were green as the grass. We put our submissions in, and not really understanding, knowing that there was going to be impact, but not really understanding the rules and how it was all going to come. The whole, what do we call it, the CIA, I think that's such a valuable document now. I've only just, recently understood that we could even have one of those to support everything that we're saying, let alone, actually get it up and running and submit it or whatever you do. But yeah, it's so valuable. I mean, there are so many sites of significance. A lot of them, like they've said, they're not marked. They're not known. They're not even known by us. A lot of them. I mean, I have kōrero about kōrere bigger than Opiako that are there. We know they're there, but we just don't know where they're. But in Waiawa, so there's a lot. The significance, I think, of that whole coastline, the historical, everything, that's got a long history, and we've been a part of that history. And so, yeah, we've put ourselves into this very unfamiliar space to try and navigate a way forward. Here's my notes. And yeah, everyone has, and we do appreciate what our neighbours do. They look after the flora and the fauna, and they have the resources and everything to do that. But there's flora and fauna, and then there's tangata, and we need to be included. I believe their worldview is very different to ours. A lot of things like I know that they have historical tours that they charge for. Well, it's just some of the things they want to monetize is just not even in our thinking, and they just at odds with us culturally. Yeah, I think I wrote somewhere, when papakainga is another important thing for us. We've been for many years wanting to go back. We've had, and it's always been a struggle, like even back in the 90s, in the previous Waiawa Bay farm owner, some of our whānau were getting served trespass notices on their ancestral land because the incorporation had leased it for grazing, but they thought they could have the right. There's these horror stories that you just think Yes. It's just been a struggle, and it's continuing to be a struggle. But yeah, that ultimately our desire is to have re-establish our apapakainga there at Waiawa, however that looks. That's been a dream for many years that we haven't managed to achieve yet. Another thing, with being the boundary neighbour, MX, we've had quite a turbulent history. We had we got close to losing a lot of our whenua through bad financial moves. But it's always been the same story, we're an incorporation, we have no money, we've got to pay rates, what do we do? And it can turn to custard. Anyway, the end story of it is that we had to get a resource consent to build, to put a housing subdivision on Matodi X lands. And that was quite a traumatic process for everybody. But during that process, there were a lot of things that we had to give up. We had to give public access. We had to provide public toilets. A lot of demands, give areas for reserve and all this. And I don't think I saw anything like that in any of these Kauri cliffs. There's no requirement to provide public access to Waiawa. Not that I would want that either, but some of the things that seem, we're like 1.5 minutes next door, but the rules seem to be different from that side to our side. Yeah. Just, I think the reality of Northland is that we're one of the poorest communities. We're the poorest region. And really, it's just like day and night, in their submissions, they're talking about first, second, third home buyers purchasing these properties, and we've got people sleeping in a caravan on the beach. Not to say that I don't know. Anyway, that was I think our biggest fear was the fear that what's the impact going to be on Waiawa Bay with extra traffic, boats, fuel, cars, visitors. And I can imagine it's going to be big. That ginormous dam that they're building. This is another conflict. I mean, I don't know. I'm not an expert. I sort of agree that water storage in Northland is great. We get droughts, but water storage to water a golf course it wouldn't be our first priority. And we know that water comes from Awawa. That comes from the Kaitāia River, which comes from our maunga, which comes into a dam. And I'm struggling to see the benefit to the community when our water's being taken, but they didn't, there's never been a pipe offered to the community that's 1.5 minutes away, or there's never been any requirement for them to offer any sort of benefit to the community. That's quite a substantial piece of infrastructure right there. That even that whole process, we were again didn't really have the wherewithal to put up any sort of challenge, or to really understand, or to really know. I know there are a few wetlands that will be absorbed into that, the different streams, but yeah, I'm no expert, so you know, it looks big and it's going to have impact, you just know it is. So, yeah, so I think we're, oh, no, what's that? Oh, we had a little conclusion. So in conclusion, what I've written on this is we would like the council to provide a fair process, a fair platform to bring our voices and expertise forward to review some of these applications. We feel council has a responsibility to prioritise mana whenua and above foreign interest. It's at its core the realisation of one family's vision for a New Zealand retreat, as per Amy's report, is at odds with the rich heritage of our whānau, hapu and iwi's vision for our future generations. Our whenua is not a retreat or a cultural attraction. So yeah, he me nui o te ao, he tangata. Tēnā koutou. Katoa.
Thank you very much. Milovan, you're listed here as a submitter also, so do you have some comments? We might have some questions for you, but I thought we might get both of your statements.
Yes, please.
Through, and then we can just have a bit of a corridor afterwards. And don't feel like we're going to grill you. We're just wanting to ask you questions.
You're welcome to.
Yeah.
You're welcome to grill me. So my name is Andrea Milova, and I have never introduced myself properly in this rebuttal evidence or these statements that we provided. So I will use this opportunity today. I am Pakapapa to Croatia, and I have finished Bachelor of Social Sciences, International Relations and Cultural Encounters at Roskilde University, Masters of Philosophy of Indigenous Studies at Tromsø in Norway. And I guess this is a good opportunity to inform everyone that I will be working alongside with Waiawa Whānau on a social impact assessment study through a PhD that will assess the impact of all of your developments, all of Waiawa Bay Farm Limited developments. And it will measure the cultural, political, economic, and environmental impacts, as well as the impacts of developments on future generations. I think that speaks for the fact that this relationship has been strained, because then if it wasn't, there wouldn't be a need for a social impact assessment study. By working alongside the whānau, I aspire to co-create reports and amplify the importance of an active consultation with ones who have interacted with Waiawa from time immemorial, whose ancestors are buried in those cliffs, who survived and thrived from the resources that the ocean and the forest provided. I also want to emphasize that none of the experts hired by Rosewood Group, nor I, are an expert on tikanga. Waiawa Whānau is tangata whenua of Waiawa Bay, the sole experts on their culture, the only ones able to measure the impact on the past, present, and future generations. To kind of go back to your rebuttal evidence, you said that you don't think it's appropriate to comment on the potential effects of your development, but you do feel that it's appropriate to assess in which stage the cultural impact assessment is required. Also, to go back to what Goodwin has said, that words become important when actions come into place. Well, in your archaeological evidence, you have said that the area had a long history of Maori occupation and European settlement. Well, I would put it the other way around. I would say Maori settlement and European occupation, because that's exactly what you're doing. You're occupying the space and you're misplacing the mana whenua of the place. You're saying that you have a long history of occupation which is 30 years long, while they have been there from time immemorial. To go back to what Amy said that the visitors want to take the most out of the experience. Well, for Waiawa whānau, it's not about taking, it's about preserving it intact. I also want to say that you're not the culture to assess when cultural impact assessment is needed. You said that Ngāti Kura has never requested it before. Well, before I came to play, they didn't know there is such a thing as a cultural impact assessment. They haven't had an equal representation. They haven't had any kind of representation. You're saying you're a small little company that is run by one of 10 richest Asian families. Well, then we can compare that to one whānau that is even smaller and has even less resources to provide their own reports. In the very first submission of the master plan, you have misspelled Ngāti Kura's name. You have saying that you have consulted with them since 2022 while you have been there for 30 years and you don't know how to spell the correct name of the hapu that you saying that you have a good relationship with. Other EV parties that you say that are all saying yes to this do not whakapapa to Waiawa Bay, which is why it's important to listen to people who whakapapa to Waiawa Bay. There has not been a consultation with EV on a frequent basis, and I am very sad to hear that the text exchange that happened this weekend is now being put as an evidence of an ongoing communication, when in my communication with the whānau prior to this weekend, Ngāti Kura had to inform Kauri Cliffs 2 weeks prior to going to Waiawa Bay, providing the registration plates of the car and the number of people in the car. In regards to environmental stewardship, that includes, well, your environmental stewardship and your plans, key plans for the future includes zero carbon emission by 2050. That includes planting pine trees that are detrimental to the environment based on the new research done by Manaki Whenua. And I also want to say that, in regards to what you have been saying, that there are no identified ridgelines in the map, we have submitted the map that shows the identified ridgelines, and it is important for these sites to be disclosed, which is why we keep on asking for more time to prepare and to map and to create our reports. In regards to pest and predator control, I do know that there are amendments to Biosecurity Act ongoing, and that Matoranga Maori from then on needs to be incorporated within the new Biosecurity Act. Since we all know that Matoranga is EV and hub specific, I was wondering if pest and predator control on the larger area will be done in consultation with the local whānau. If the master plan is actually indicative of the fundamental values, why is cultural impact cultural impact assessment not one of the core values within the master plan? If there was a better consultation, you would have known about the ridgeline and about the unrecorded archaeological sites. In regards to the walking trails that you have reviewed, that they don't concern Maunga, they concern the whole area, and they concern the ways that Waiawa whānau does not want their culture to be exploited in such a way. There hasn't been any consultation about the informative panels and so on, while Kauri Cliffs is priding themselves on a philosophy called sense of place philosophy, with one of the key elements being cultural authenticity. Well, this is the culture. They're the culture, and they have been constantly saying no to any of the developments so far. So I think that's what I want to say. To go back to also what Amy said, that lately there has been communication which includes great outcomes for everybody. Well, not for Waiawa whānau. I think that's it. Have I forgot something? Okay.
Do you wish to say, sorry, anybody else want to present? Obviously, engage.
I haven't prepared anything.
But you're welcome to say something to us if you wish.
Well, maybe if I could give a bit of background on Te Whānau Nui o Waiawa o Ngāti Kura. We are a whānau group. We are what you would say directly impacted by Kauri Cliffs, in that we are their direct neighbours. So that line that you see on the map, on the other side of that line is where our grandparents lived and grew up, my father and Murray's family as well. And so we are the small whānau directly impacted by everything that happens at Waiawa Bay Farms Limited, Kauri Cliffs. We are a whānau group inside Ngāti Kura who are managed, and our lands are managed by Kaitāia Incorporation. And so Moana mentioned previous years that Kaitāia Incorporation haven't always been successful in applying what their shareholders have asked them to do. And at some stage we've actually also had to stop them from doing 60-year lease on our part, which is, you know, directly next to Kauri Cliffs whenua. We are the children of those who originally had to fight our own land trust to stop doing that. If that had happened, our grandchildren would be 60 by the time, they could even go on their land. Also, Kaitāia has changed hands since Anaru was chairperson. Trustees have changed since Anaru Kira was chairperson. And I just noticed that and Geraldine Baker, she's a trustee for MX Incorporation and a shareholder, so is Anaru. Anaru is also one of our resident kaumātua, and he also sits as head CEO of an organisation called Papahapu, and they are commissioned to administrate our claims with the Crown. So, as oftentimes happens, sometimes you got a few portais on your head, and you know, I've experienced it. You can tend to forget to take off the appropriate portais and only leave on the one that's appropriate for the kaupapa of the time or of the day or at that time. This is what we believe our kaumātua did at the time in the initial consultation with Kauri Cliffs. And we have actually talked about it with Amy and Jay and as a whānau. So we didn't support his submission, his cordial in his letter that he submitted in support of. And we've had meetings for that as Ngāti Kura Hapu. We've had meetings to that effect I'm not sure what the word is, but to say that we do not support that letter that Anaru presented for their RCA. So that's just a little background. We do most of the interactions with Kauri Cliffs and Waiawa Bay Farms Limited because we are the whānau who live directly on the other side of the boundary and are impacted, affected in all ways by anything that happens, any changes, anything. And the land there is, we holiday there, we wish to papakainga there. At the moment, we've got no structure there. We don't even have a proper road to allow us access to Waiawa Beach. And then, so we have to have a relationship with Kauri Cliffs so that we can have access. It's a little bit, you know, as tangata whenua, as it's a little bit offensive for us, I'm sorry to say, but, you know, having to ask for permission to go through what was our ancestral lands. And then, of course, we've had the issues of not all the whānau, you know, agree to, you know, the agreements that we've made in the past with that. And so that can be difficult, I know. We wish to continue to live there, but we're trying to find it, how can we do that when we've got such a higher living on one side of the boundary, and then us who just want to camp, put up our tents, go fishing, half naked, mokopuna running around, you know, and all of that. How do we live next to each other? And, you know, with that, we're whānau, we're not commercial. We think, we feel from a whānau perspective, and we also, obviously, as Māori, we think not just of us and our moko, but our moko's moko as well. So we obviously want to set up a situation where our moko don't have to come back and do this all over again.
Well, thank you very much. I'll see if we've got some questions. But Ms. Miliband, you appeared to be reading from a statement. Are you happy to make that available to us?
Yeah.
Would you like to submit it
Absolutely,
in written form?
we are going to prepare something within these 2 days to give to the council, but we also wanted the opportunity to respond to what they are saying. So I did prepare something. I also kind of, I was also creative to submit the whole thing.
If you would like us to have a copy of that, you could email it to Alicia Kate here, and we can have that recorded as a. We've got your hearing statements that you gave us previously.
Yeah.
So if you'd like that to be added to the record so that we can have another look at it when we get down to consider these provisions, that would be helpful.
I would be very happy to, since, considering everything that had to be said, I didn't manage to say everything that I have written down.
As long as the statement just covers the matters you addressed today.
Absolutely, it does.
Sione, would you like to lead on?
Thank you all for your kōrero. Thank you, Moana. Definitely felt that sense of frustration and confusion from you. So appreciate you being able to speak to us and feeling uncomfortable. But, you know, we're here to listen. I think it's hearing the voice as opposed to trying to present in the best way you can. Just wing it, you did it well. So thank you very much for that. Kia ora, Vicky, for giving that context and background, because that sort of related to one of my questions about ahika. So you are ahika, you're on the other side of the boundary, so you're the home people living it there front and centre. And thank you, Andrea, for your commentary around, you know, you're working with the hapu, or the whānau, sorry. I would say whānau, would that be correct, as opposed to hapu? Yeah. Working with the whānau as part of your PhD, and it becomes something that helps build their awareness and capability of these types of processes too. So thank you for your kōrero around working with the whānau on that sort of stuff. I appreciate the correction of the name of who you're representing. It is in your evidence as well, Moana, and your clarification that you are whānau of Ngāti Kuri and you are the home people.
Ngāti Kura.
Kura, sorry. Ngāti Kura. Thank you for the correction. So that that was good to hear, the clarification, and having an awareness of your lands are managed through trusts along with Matodi X and the role of Anuru and those dynamics. So I'm aware of iwi, hapu, whānau dynamics, so I get that. And sometimes I think other systems or people don't necessarily have an awareness of some of those systems. And so thank you for clarification for me on that. In your evidence, yep, strongly oppose. I had a sense of a lot of that stuff, but what I did pick up from your initial, I think it was statement or, your initial one. Sorry, I'm just going to make sure I got the wording right. Your submitted material and evidence, that's what it was called. Because what that told me, it told me about your whakapapa, it told me about your resources, it gave me a bit of a story about you, which was coming through from that perspective. So thank you for that. I was able to get that sense, and now you've spoken to that as well. That has added to what you've written there in your text. And then you've got your, sorry, too many tabs open, your rebuttal, which talks about te whānau nui o waiawa o Ngāti Kura as well. So having those maps and understanding that context from your perspective, presenting that in the rebuttal as well. So getting to a question, sorry. So with a lot of the opposition, you know, you're wanting a CIA, you were saying, and that's where I was asking the Waiawa Bay team around a CIA and where they saw that CIA. And so the comment was, it's not for you to tell us where CIA should be part of the process, as in the team, the Cody Cliffs team. You know, it's mana whenua, haukainga, telling their values and what those are. So I do see a value in regards to understanding the context of that whole area. And then when you come down to resource consent process, that again is another process, but is hopefully informed by wider values. I think people get stuck in the detail of where did you stay, what did you do, but what I have heard from the Cody Cliffs team, you know, they've got protection around the caves and they've had an awareness of some things. So they've got knowledge from when the Cody Cliff, the golf course was done. So they've got a bit of background that's helped build and inform what they've done. My question I've got is, how do you think the cultural values could be integrated into the Cody Cliffs special purpose provisions? What would you see or what mechanism would work for you, the haukainga or the ahika, I should say, with your neighbours next door? So a mechanism I can think of generally can be memorandums of understanding, high-level principles, you know, we'll agree to come together and have a conversation and do this, that and the other, or memorandums of agreement. They tend to be more operational, but what sort of mechanism do you think might be useful for you going forward to be able to work with your neighbour, communicate and convey your values and all those types of things?
Yeah, we quite. No, I think it's useful. I've always got the sense of the horse is already bolted, you know, and it's like, yeah, it's too late. I think you know what you're talking about, memorandums of understanding. Like Amy was talking about when they did the logging on the maunga or around the bottom of the maunga, and there are definitely things that we're aligned on. You know, we want to have Papatūānuku reclothed, and when, you know, we probably don't really have a lot of the resources to do that. So, you know, no mai haere mai, please do.
Yeah.
I don't know. I sort of feel like, you know, like with all the council stuff, the building consents and the resource consents and that, and even with the consultation, it's like we will have conversations and we'll put our hearts on the sleeve and tell them all why it's also special to us, and then they can say, well, thank you very much, that was lovely, and we're going to continue on our merry way. You know, it's like our voice is just going off into the ether. Like, I think we need to. I think that's what the CIA's, I'm hoping, will.
I'm just wondering, it seems to me that there's a clear message that you want to participate, but it's a matter of resourcing to be able to participate. Because I've heard your evidence that said you're getting bombarded with information. You've got, in order to participate on an equal level, you need to be able to get people who know about archaeology and civil engineering and landscape and planning provisions to advise you as well. So is that the
yeah, but I think we don't always want to just rely on their experts.
Yeah,
like we want to have our
own experts. Yes, I think this is my question to you. You want to participate on an equal footing, but that requires resourcing.
Yes,
to be able to answer to, because you're not planners and engineers or architects, landscape experts. And I don't know whether it's the role of the planning provisions to allow that, but I'm hoping Wild Bay Farms is listening to where I think the disconnect is occurring is if you want a truly iterative, equal participation, you know, you need some resourcing. I think that's what you're telling us. Or am I putting words in your mouth?
No, absolutely. You know, there was all three. There were different options for us. Well, you can get a lawyer, and well, you can't when you haven't got the money, can you? So you know that idea went begging. You know, we went through a whole list of how can we start to navigate all of this. And
if I can respond to this, PhD was not in the question when I first met Waia Whānau. It came into question because we needed resources. So while I was trying to get some experts working on this case, because I am still learning and will continue to learn, so I can support them in their wishes. That's when I met with an expert who has suggested to apply for a PhD so we can provide those resources.
Okay, thank you.
Yeah, I think that the reason I raised the component of the mechanism is you made reference to resources. You don't know what your resource, you know, the tuas, whatever it is, those elements of, you know, the water condition, your role as kaitiakitanga, you know, there are multiple, you know, is there the opportunity to monitor works that are in the vicinity of the waterways, tributaries or awa that go to the coast? Are there opportunities to be a part of the archaeology processes when they go and do those types of things? So it's building your capability of, you know, what you're looking for, but also you're understanding their processes on what archaeologists do, how they do and why they do. So I think there were a suite of things, you know, water quality, resourcing is another one, and a whole lot of other things that are of have a sense of, you know, your cultural values and components, tupuna, all those sorts of elements that are there, but those are all like sporadic. So what is that sort of mechanism that could say, actually, high level, here's where we agree to do X, Y, Z, and then you can take it down to the next level, as opposed to the sense of resource consent processes as a CIA, and we'll do it then. However, again, it comes back to resources. Well, how will that get resourced, and how will that be implemented, or will it be implemented? There's a whole CIA process and that relationship process are two different things. So I think that's why I asked that question. And as I asked the team as well, what sort of mechanism is in place, and it was again back to the relationship that they presently have with the various iwi and hapu, as well as the opportunities through the resource consent process, if that's what you want to call it, an opportunity. So that was sort of my sort of what's a way forward, as opposed to iterative, do it every time you do a consent, because that's where you're struggling. So that's where I sort of wanted to get your thoughts on that. That's with the cultural values and everything.
If I can respond, I'm not sure if it'll answer your question, but as Te Whananui or Waiawa or Waiawa, we represent the whānau in our whakaaro. And so it's hard for us to respond, to give you an answer or to respond immediately. As we've already pointed out, our language, we have a language barrier. And so we would have to, you know, go and have a powwow about it, go back to our whānau and present them with that. And then together we make a decision. And then mostly we put moana out the front. And then we respond that way. I know it's a very long process, but it's the only way we believe that we can keep it tika and pono for our hapu, because otherwise we have our koea, mostly our koea left, and they're the ones behind us constantly saying this, saying that. So we can't make decisions without them. Also, on that, we have done research on Jay and the family, you know, and Kauri Cliffs, putting aside the, you know, issues that we might have had in the past, like our parents and grandparents, for instance. But do you know us, our whānau, Te Whananui or Waiawa? And that was the reason why we invited a visit to the marae at the time, so we could get to know each other personally. And it was advice given to us through a hui that we had with FNDC. So we did that, but today we still don't actually feel that the whānau know Te Whananui or Waiawa. And so to us, it's sort of come to our realisation that because we are speaking different languages, we also, we're speaking from a cultural point of view, and yours is another. So we're always going to have difficulty coming to an agreement. So we thought, and it was suggested to us, that we, a cultural induction for Kauri Cliffs. To us, that means that will, you know, raise the level of our communication, our language, to be a lot more even. And so when we speak of, we go into a lot of tikanga and we go into a lot of te reo, because sometimes using the reo is the only way you can explain something. And we find it hard to explain that in English terms, you know, let alone commercial terms. So we feel that would be a good start for what you're saying. Is there something that we could agree to yes, and a cultural induction, we would feel comfortable with that to start that kind of kōrero.
Thank you. That's encouraging to see the potential approach, and also it was encouraging to hear from Amy as well, who said, you know, open for discussions and understanding and a way forward. So that's quite useful, as you say, as a way forward for discussions and yeah, not bringing language together, but having a bit more awareness is what I find cultural inductions tend to be, and I'd assume that would be at the marae, as we do. And it's also, yeah, encouraging to hear that Amy, and no doubt I'd assume the specialist team would potentially be a part of that conversation. And then you can build on that on a way forward. So, yeah, that's good to hear that. Thank you.
Kia ora, just help me here. This, I can't really tell on the map here where your whenua is. It's quite broad, the dots. Is it this? Can I just show you?
Have we got a marker pen? You could come up and just like circle for us, perhaps.
Is it a separate licensed to occupy area, or is there an occupation order that sets out the whenua?
It is a map that we submitted to prove that
Is this
there
your
are more
property?
archaeological sites
Are you
that
the
are
red dot?
defined within the master plan.
No, that's the one.
Because it shows 2 more additional archaeological sites that have not been recorded in the master
Yeah,
plan.
that's our actual
It is,
registered Wahitapi here.
Yes,
This is Waiawa Bay here, so all of this is belongs to MX.
yes.
And then
And your
so
whānau?
this is actually
Whenua?
Waiawa Creek, which is our boundary. And yeah, so that's the Wahitapi where our whānau. There's currently no one living. It's not accessible. In the winter, you can't even get down the track. We have access via boat in the winter, or a goat track during
So
the
here's
summer.
Matodi X,
No, this
the whole,
all of this is Matodi.
and then this is the subdivision. That,
No, that's not. That's Te Tapuhi Road, so our marae sits up here, and then there's a little housing development here, and then down the bottom towards the beach, there's more housing. High and developments in there somewhere.
So that's road down
Oh,
This is-
yeah. Yes, that's Waiawa Bay.
there. So where's the Papakainga area that you were intending? Is it
Aspirations, yeah.
is where that dot is, or? Yeah, but some,
that-
you might want to
Yeah,
go
in that,
near that.
in that area,
Oh,
in that
yeah.
area, that's what, that is where
This grass
traditionally.
area.
Did we give you that other map of,
Yeah, no.
the old map, no, the 2014 map?
The
Oh,
reviews
that's-
of
And
evidence.
that's the one that shows where, like, shows all the original whānau.
Yeah, and the ridge lines.
But this is a map we've been given.
No,
That's
one
No,
of,
you want this
your
one.
evidence, yeah.
You want
Yeah.
this.
You're
Hang
in
on.
the-
The original.
so this map
We're
was,
talking about this map.
yeah, that's the old one. So all of these little things here are,
So this is the
whānau.
stream.
So that's my tupuna there, purple. But my grandmother was born in that little, in 19.
So this piece of land, could you just roughly show it on one of these plans?
Yeah. So that's just, it's all around here. Okay.
Okay, and look, we're happy to show this to you as well, but literally she's just drawn a mark on their plan as to where area of land that you occupy.
So your mana whenua
Papatū.
specifically is a whānau, and your acre of.
Two right there,
This-
two there, yeah.
Okay. But
Yeah.
did you want to?
No, it's okay. I just wanted to kind of go back to the protection mechanisms.
It's
we
just
were
getting us an understanding of where
Yeah,
where you the place that you go to when you say you've got access,
yeah, that's where we go.
and where we
That's where
wanted to
go, right
understand where that land roughly
Yeah,
is.
right,
Absolutely.
right there to the creek boundary of the neighbours, right, sit in the bottom.
Okay,
Oh, thank you.
obviously you get the opportunity to draw this plan again for Carrie Cliffs in your next engagement.
Mhm.
I mean, this map is just an example of that there are unrecorded archaeological sites. So to go back to your question about the protection mechanisms, I think we're still trying to identify those, and that's why we keep on pleading for more time, because there's still so many things unrecorded. I just kind of started working with the whānau, and there are thousands and thousands and thousands of documents to read and to dissect. So that's why we need more time to understand which protection mechanisms to use, which sites to record, and so on and so forth.
I'm here. Oh, so Anaru Kura, Kira, he's part of your whānau group? Kaumātua of your
He
whānau
does
group? Is he ahika?
He does whakapapa too, Waiawa as well. He does.
So he submitted a letter on behalf of the whānau?
No,
or the
not
hapu?
us. Yeah.
The hapu.
It's the trust, part of the trust.
Well, we're not sure because it was blanked out, so we're not sure what portai he had on when he. That was one of the things that, like most of this here is just resource consent applications, and all of that with all these reports, everything else. There was the one page from Anarikira that said, on behalf of Ngāti Kura, I've seen the plans and I support the application to build the pavilion down at the bottom. And like, he never provided any plans or he never came to the marae and said, look, this is what I've got, and this is, he had those things for a whole year and didn't show a single person. It was like he was just a lone ranger at that point, which was, that's why we found it so distressing that we didn't even realise anything was going on until come summertime and there were pegs in the ground. And that mystified me. How could it have got that far down the process without... There was confusion because Ngāti Rehia, who are the southern boundary neighbours, that's Nora Ranaka, and they have that they can do the environmental studies and all the rest of it, but they sort of stop basically at Tako River, so anything further up from them. And then there's Ngāti Turahina, which includes us as well. It's Ngāti Turahina, Ngāti Kura. And then like the Runanga Whaingaroa, so they would get information as well. But our marae is not actually, I think the Runanga looks after about 16 marae in our ruhe, but actual Matoti Bay marae is not registered with them. So we're Johnny on the spot right in the middle, but none of the communication was getting to us. It would go to Ngāti Rehia in the south and Runanga Whaingaroa in the north, and we were totally missed. That was happening some time, apparently.
After 30 years of occupation?
Yeah, I think we have got the council now, given them the details to at least come back to just the marae with any notices or things of interest for us, but...
So there was no meeting held with the hapu to support the letter that Anarikira put to Kauriklas. So he didn't have the support of the hapu.
I had a question as well about environmental plans. So hapu environmental plans, and that would include, marae and down to the whānau level, as you said.
Yeah, we don't have one. I know...
Not a completed one.
I don't think we've even started one, have we? But I know Ngāti Rehia have an environmental team in the Runa, and Whangaroa have one as well. But Not us, not
We are
right there.
working on it.
We need one,
Yeah.
obviously.
In terms of your protection of your taonga tuku iho, that as well doesn't need to be public. There's what's called silent files, so that essentially there can be a protection mechanism, but it's not made out to the public. So there's a provision under the Act for that as well.
Yeah, that would absolutely probably.
So, potentially could go back to the Runanga and ask them for that assistance in terms of those processes. I guess the other question that I had about Waiawa Bay, which is obviously a key taonga for you, is Ahika. The proposal that we've seen for these changes, and we've looked at these plans spatially, they're reducing the areas that are to be developed, and as they said, they haven't proposed any areas adjacent to the moana. In fact, they've moved them back and they've reduced it by, I think, over 100 hectares of area. And they've said that they were clustering certain buildings into certain areas. Are you able to give any comments around that reduction and being more specific about where they're wanting to cluster the activities and essentially the way the plan is proposed to be changed?
Yeah, well, I think for me, like, so, well, location-wise, okay, so we don't really know what's there because we don't know what we don't know, do we? So, we don't know what isn't there to be discovered or not. And in Kirikiri, you do a standard subdivision, you sell the sites, and that's it. But with this, what they're proposing, it's a different concept. The concept is that you buy, well, I suppose you get a sales and purchase agreement, you buy your lot, but that gives you access to the wider property. And that's where we get tripped up because that's where it's going to impact on us the most. It's not a straightforward just a subdivision. You sell the sections or the lots and they stay on their one little 1 acre block, half an acre block or whatever it is. This whole concept is different in that it sounds like you buy in the Cody Cliffs zone, and that gives you access to all these other areas. I'd rather not, to be honest. That's where the pressure is going to come on us. It's going to come onto the beach, and I read things, and you think that there's protections with the. They say that if there's already a compromise, well, Matodi Bay has been open to the public. Mairano, every man and his dog has always been allowed access there. And it's like I feel like we're going to degrade another coastal beach, like a wild place, when there's already one like 2 minutes down the hill. So if you want to go fishing or swimming, can you not go 2 minutes down the hill and fish and swim there? Do they have to, does it have, I don't know, that's that whole, it's gated communities, it's all those sorts of things that are concepts that are a little bit new in New Zealand, but they're coming more and more.
Yeah, if I could add to that, it's an increased human traffic to Waiawa Bay that hasn't had that number of people coming and going on a daily basis. It's light pollution that is going to potentially going to impact taonga and wildlife that Waiawa whānau considers taonga, such as bats. So, of course, it is a residential development that is situated on the top of the hill, but that doesn't exclude all the other effects of that residential development in the sense of access to the beach and the light pollution that it will create.
I had just a last question about the master plan. I'm guessing, so seen the master plan. Currently, it's not part of the criteria or matters of consideration. Is there anything that you would say to give feedback about what you've seen in the master plan to address any of your concerns?
Well, I think that's always been our main concern is the pressure of the extra population that's going to come on the beach. That's a big one for us. You know, I guess it does make sense in my brain, you know, clustering little, however they're going to do it, but yeah. Yeah, I think that's always been the biggest concern. But
We were also trying to find records of when Waiawa Bay became a private property because we hold some records back in 1993 that it was Maori Reserve. So we are still trying to dig out that history. When we saw that, because from my conversations with Waiawa Whānau, it was a public beach based on their knowledge up until the master plan came out and the bay was marked as owned by Waiawa Bay Farm Limited. So we are trying to find records to when did that happen.
oh, yeah, it's the actual coastal zoning. Like we thought it was like Māori reservation along that there. Not sure what it is actually. Well, there is a record in the Māori land book that it was set aside for.
Maori Reservation.
So yeah.
There was also some dispute about the stream, right? Yeah. So who owns the stream and when was the ownership transferred? Because there is some missing documentation in regards to that. So yeah, there is a little comments here and there in regards to the master plan, but again, we're still trying to figure all of that out and to dig out those historical evidence and to see where things have changed and at what point.
This is all pre-Kauri Cliff, so.
Kaitāia.
Okay, thank you very much. I've just got one quick question for you. We're going out there tonight, and he's going to be showing us around. Is there anything you'd like us to pay attention to, and for what reason?
Well, the first thing that comes to my mind, to get a picture really of our position, would be to go down to Waiawa Beach and look to the left, and that's where we want to put our whakapukanga, and that's where we holiday every year. And you'll also see that we don't have great access to the beach because there's an awa in the middle, in the way, should I say. And so, I mean, we do manage it, of course, because we've been doing it for years. So you kind of have to go up against the side of the hill on the other side, but it's kind of fenced off. So we drive across it, or we just walk across it at low tide to get to the beach. Yeah.
So when you say
That would be
look
good
to
if you
the
could go and
left,
have a look. So you look to the
but
left as you come
mean
down.
north. So we're standing at the
your
beach looking
Out.
Out window, down
so
to your left.
left is north.
Left us not.
Across to the stream, cornered.
Across the street.
I just so
Go to the beach,
what-
look
what-
left, which is north.
Yeah.
Yes.
Yes. What actually is
For the planner who has
the
absolutely no
zoning
sense of
for the
direction, I need to be. Okay, so we'll do
So
that.
is there any significant natural area zoning still left in any of that, or is it all gone, or?
I don't have the answer to that question, but it's possibly a question we can put to. Can you answer that question, Mr. White, quickly?
I'm sorry.
Sorry, what was the question?
The question was, are there any significant natural areas? Well, the council's not mapping those at the moment.
No, actually, no, it was called an outstanding natural landscape. Yeah.
That would be mapped because that would be in the regional planning maps.
Yeah, and if that applies to that area, the actual beachfront, do we know that?
That's a good question. I'm happy to divert to our learned council expert here. Mr. Goodwin might know.
There's financial character areas.
Yeah, it's an outstanding natural landscape. Yes.
There we go.
The whole area along the coast there is.
Mhm.
And there is there is a high natural character area
As well, on the beach.
itself.
Okay, so just to clarify, what Mr. Goodwin is saying is that the entire area is an outstanding natural landscape and that there's a high natural character area that covers the beach.
Beach and the immediate forgery.
Yeah.
Right, okay. Mr. White,
Am I right?
you
I was taking a
concur?
look at this, it looks like the outstanding natural landscapes to the north, high natural character along the beach.
Oh, I got it wrong. Sorry. Oh, yes, you're right, sorry, the outstanding,
I didn't
That's
get
outstanding
that.
natural character there.
that's simple.
Yeah, and then it's the high natural character there.
No, I don't think it does.
And you know, further to that,
I
does
think your
that,
question was, is there protection over the beach?
yeah,
The answer is
yeah.
yes.
Sorry, my apologies.
Yeah. The outstanding natural landscape is to the north of the beach itself, but there is a high.
Into the Matauri X land.
Yes, and so there is a high natural
So-
character area.
we have the restrictions, but not,
Well, the beach does. In terms of your land on the Matauri X land, it looks like they've got the high net. Having said that, we've been through all of those hearings already, and it doesn't stop development.
no, but there is stricter,
There are, yeah. I think you've got to be careful too.
so many rules.
Yeah, that's a fair comment. Okay, well, hey, thank you for that. We'll make sure that we do. See, getting to that beach, there we go, it can be done, and so that's what we'll have a look at. So thank you very much for your presentation. I hope you didn't find it too daunting. Your presentations and your answers to our questions are really helpful. We've learned a lot from you, so thank you very much. Right, so I think that ends now the Kauri Cliffs segment, Waiawa Bay segment. But we're now moving on to Carrington, correct?
Hi, Kaitāia, Marae.
Yes, okay.
Yes.
Okay, so look, nobody, unless you want to, if you'd like to leave now, that's fine. Our next presentation is actually going to be online, so nobody has to get out of their chairs if they don't want to. So we'll move on to that. So we have a presentation from Kaitāia Marae Kaitiaki Trust. Can you hear and see us?
Yes, we can. Can you hear us? Hello?
Hello.
Hello.
Just having a bit of one submitter is just leaving. Lots of submitters are just leaving, so maybe we'll just give it a minute.
No, Katie Pai, just while they are leaving, I just acknowledge the whānau from Ngāti Kura. My name is Jason Poe. I'm from Hokianga, Ngāpuhi as well. Just acknowledging the kaitiaki of the birthplace of one of my tupuna, Waiawa, is of course where Wakanene, the great Ngāpuhi chief, was born. So just kia ora to you. It's a privilege to come after you fellas.
Yeah, nā koe, Jason. Nā mihi. Oh, who knew that?
Organising. I also have an apology to make. I've been calling Miss Tahia Alice Kate. I put my glasses on and read her name properly. It was Alicia Kate, and I was trying to correct Ms. Ehrlich for calling her AK, and I think I've undone myself. So apologies, Ms. Ehrlich, AK.
Okay, right. Well, the room is now yours, and there's just us and the council officers here, and Mr. Sanson. So we're in your hands. We've read your legal submissions, and we've read the planning evidence that's been submitted and the rebuttal. But we'll leave it in your hands to provide us a summary of to us.
Just for your benefit, Mr. Tipene Paul can't be here today. There's a tangi up at Ngāti Kahu. So his evidence sits there. If there are any questions that need to be asked about that evidence, they could either be put to Ms. Ehrlich, who's going to be helping me with the submissions, but she's also from Ngāti Kahu as well. But probably the best way forward is for any particular questions specifically on his evidence to be put into writing, and we'll try to expedite his responses to that. I'm going to have Ms. Ehrlich is going to summarise the positions, and I think I sent this out in an email to Ms. Tahia. Then we'll have a bit of a unless you have any questions in terms of the framework that's been set out in the legal submissions, then we'll pass over to Mr. Percy, who is online, who I can see. And then if there are any questions, Ms. Ehrlich will probably do a roundup, but just watching the way that the panel has conducted itself, we want to leave some space so that we can answer any questions, probably collectively if that's okay, might be the most constructive way forward. So unless you have any questions around those sorts of logistics, I'll pass over to Ms. Ehrlich, and she can summarise. We do know that everything's been, you will have read everything, so she's going to hit some key points for us.
Yeah, okay, so before what I want to do is I want to put a question to you that I put to the Ngāti Kura submitters at the end, but I want to put it to you now so you can have a think about it. We are going to visit Carrington Estate tomorrow, and I think they're going to allow us a vehicle to have a drive around. Have a think about anything you would like us to particularly pay attention to or observe. You don't have to answer that yet, but perhaps maybe at the end of your presentation might be able to give us an indication if there's anything you'd like us to pay particular attention to.
I think that there's a map in the evidence of Mr. Paul. That's a good way to sort of orient yourself in terms of the way that the hapu sort of perceive the area. Ms. Ehrlich will highlight three areas further as we sort of move forward. But thank you for the indication. We do think it is a really good idea for you to do so. So other than that, Ms. Ehrlich.
Ahi Mario, can you hear me okay?
Yes.
Perfect. Just before I do turn to the legal submissions, Mr. Percy prepared a preliminary iteration of an amended set of the Carrington Estate zone provisions, which we filed on Friday. We apologise for the lateness, but we did want to check that a copy of that document is with the panel.
Yes.
Yes. Yes. Perfect. And just to clarify my name, you may have my role rather. You might have noticed that my name was on the submission. At that time, I was a trustee of the Kaitāia Marae Kaitāia Trust. I have since resigned. So turning to the legal submissions, Part 1 sets out Kaitāia Marae's interest in the proposed plan. Te whānau moana and te rorohuri a mana whenua of Karikari Peninsula and mana moana of the surrounding waters. These hapu whakapapa to Kaitāia Marae, and the trust was established to assist with environmental matters. Part 2 of the submissions addresses the context relating to the Carrington Estate Zone The origins of the estate zone lay in 2 resource consents that Council granted on a non-notified basis in 1999, and a 3rd resource consent was granted for subdivision connected to the 1999 consents in around 2003. In the same year, 2003, Carrington Estate Zone was introduced, which effectively embedded activities authorised by the consents into the plan by classifying them as permitted activities. The Carrington Estate Zone is located within the rohe of Te Whānau Moana and Te Rorohuri. Since 2003, some activities have been implemented and some have not. Mr. Percy addresses this at 2.3.2 of his evidence. Broadly speaking, the activities that have not been given effect and that are permitted by the proposed plan include 230 accommodation units up to 10 metres above ground level, 113 accommodation units. I would have to ask Mr. Percy to define or identify whether there is a definition of what that looks like practically, the associated earthworks, landscaping and infrastructure. The context also includes the new policy documents that have been introduced and come into force since 2003, and that includes the New Zealand Coastal Policy Statement, the National Policy Statement for Freshwater Management, and the New Zealand Planning Standards. In real terms or tangible terms, the cultural Carrington Estate Zone is located upstream and uphill from Waimango and Karikari. Mr. Poole identifies that both of these areas are of cultural significance and traditional mahinga kai sites. In addition, Waimango provides habitat to vulnerable, so threatened or at-risk species. Wairahuraho Awa, or river, is partly within the Carrington Estate Zone, and it was also a traditional mahinga kai site. The water bodies are interconnected, so we have puna or freshwater springs that lay beneath the surface of the Carrington Estate Zone whenua. They feed Wairahuraho Awa, which flows downstream to Waimango and to Karikari Moana. A further common theme to this catchment is that the water bodies have become degraded due to activities within the catchment and existing stresses. The context also includes technical terms that the Carrington Estate Zone partly encompasses and otherwise sits adjacent to the coastal environment. Waimango and Karikari have been partly identified as Owenau, and of course there's the natural character elements with parts of Waimango identified as significant ecological areas. Part 3 of the submission covers the court proceedings, and we do consider it important to speak to these proceedings as there appears to be some confusion, if not conflation, with the present process. The Trust sought declarations from the Environment Court that the consents had lapsed. So these are the consents issued in 1999 and 2003. During the course of the proceedings, Carrington sought cross declarations that the consents had been given effect. Ultimately, the court decided not to make a declaration either way, and Kaitāia Maraenga Marae have appealed that decision. Importantly, the declarations focus on the resource consents. They do not and will not concern the proposed plan, and that includes the Carrington Estate Zone and or any overlay such as the Coastal Environment Overlay. We have reviewed the legal submissions for Carrington, and it appears that we are agreed on this point. It's equally important to note that the court proceedings do not negate and will not impact statutory obligations relating to the proposed plan or to Council's core functions. In the Section 42A reports reliance on the consents to justify the Carrington Estate Zone provisions and the expression of reluctance to act due to the pending court proceedings, or in terms of those portions of the Section 42A report, our submission is that they are misplaced. If the court ultimately finds the consents have lapsed, the current Carrington Estate Zone provisions would effectively entrench an outdated and permissive planning framework. If the court ultimately finds the consents have been given effect, associated rights may be exercised irrespective of what the plan provisions say. Part 5 of the legal submissions outlines statutory requirements pertaining to the proposed plan. Broadly speaking, there are 4 mandatory considerations. The first being that tikanga is relevant as it forms a part of New Zealand law, and this was recently reconfirmed by the Supreme Court in Trans-Tasman Resources. Mr. Paul's statements of August of this year and August of last year articulate Te Whānau Moana Te Rorohuri tikanga principles and how they apply in this context. Section 31 RMA prescribes council's functions, which we cite at 5.3 of the legal submissions. And we add that the RMA, this section 31, expressly states all functions are designed to give effect to the RMA's purpose. Third, section 72 RMA sets out the purpose of the proposed plan, being to assist council to carry out its functions in order to achieve the RMA's purpose, which is guided by the Part 2 principles, and we will come to shortly. Fourth, section 25.3, subsection 3 requires the proposed plan, including the Carrington Estate Zone, to give effect to higher order instruments. In King Salmon, the Supreme Court interpreted to give effect to mean to implement. Importantly, the RMA does not require the proposed plan to align with, accommodate, or give effect to the consents. There is no RMA provision that endorses this kind of an approach. And when we look at section 104 RMA, it is clear that activities relating to resource consents are to be evaluated against planning instruments, not the other way around. Carrington's legal submissions assert that there's no relationship with the Carrington Estate Zone provisions and the consents. The position adopted in those submissions is unsupported by its own evidence. Mr. Sanderson makes it clear that the purpose of the Carrington Estate Zone is to, and I quote, enable the development to proceed as it was consented. For reference, we draw your attention to Mr. Sanderson's evidence, for example, at paragraphs 24, 27, 32, 33, and 57 to 58. Mr. Percy agrees with Mr. Sanderson's evidence. Together, the evidence highlights that the Carrington Estate Zone represents reverse engineering and that they focus on giving effect to the consents rather than Part 2 RMA and higher order planning instruments. This approach is contrary to statutory obligations, planning directives, and council's core functions. Part 6 of the legal submission address the tangata whenua provisions of Part 2 RMA. So that is section 6C, being the requirement to recognise and provide for Kaitāia marangai marae, culture, traditions and ancestral relationships the Section 7A duty to have particular regard to kaitiakitanga, and the Section 8 requirement to take Te Tiriti o Waitangi principles into account. Case law establishes that these particular principles are important considerations to be borne in mind at every stage of the planning process. It also establishes that tikanga and cultural values are best identified by tangata whenua, as those values are relational. As noted earlier, Mr. Paul's statement speaks to their tikanga, their values, and the relationships they have with both the whenua within the Carrington Estate Zone and the areas downstream from the Carrington Estate Zone. The inextricable connection that Te Whānau Moana and Te Rorohiri have with their rohi means the harm to these areas, or any harm that might occur to these areas, ripples through their values and relationships, including in terms of their tikanga, identity, traditional practices, and ancestral relationships. To date, there has been no assessment or meaningful consideration of the effects Te Whānau Moana and Te Rorohiri will experience in relation to the activities that are currently permitted by the Carrington Estate Zone provisions. Although Council was aware that the Carrington Estate Zone sits within the rohi of Te Whānau Moana and Te Rorohiri, it chose not to engage directly with them. This has predictably led to fundamental Part 2 obligations and considerations being neglected rather than treated as important considerations. Part 7 of the submissions address the National Policy Statement for Freshwater Management. Our core submission is that the Carrington Estate Zone does not give effect to this instrument. Key concepts like te mana o te wai, achieving integrated management, ki uta ki tai, from the mountains to the sea, and restoring the balance between water, land, ecosystems, and community are seemingly ignored. Mr. Paul's evidence is that the Carrington Estate Zone encompasses and is otherwise upstream from freshwater bodies that are interconnected and currently unhealthy or unwell. According to their tikanga, these water bodies require protection and restoration. A tikanga-based holistic approach to freshwater is not just culturally appropriate. It is mandated and required under the NPS-FM. In our submission, the lack of reference to the NPS-FM represents a lacuna in the proposed plan. This is inconsistent with the requirement to implement it. Part 8 of the submissions addresses the New Zealand Coastal Policy Statement. And similar to the NPS-FM, our submission is that the permissive Carrington Estate Zone provisions fall short of giving effect to the NZCPS. In Te Runanga o Ngāti Whātua and Auckland Council, the Environment Court confirmed that the spatial proximity is not determinative of whether the NZCPS applies or is engaged. Instead, catchment context, cultural values, and ecological linkage are. In that case, effects from an activity in Doe Valley were assessed in relation to Kaipara Moana, which was some 30 to 35 kilometres away. The Carrington Estate Zone is located, as we noted earlier, upstream from ONL, areas of high natural character, and SNA, or significant ecological areas. It lays within the same catchment, and I understand Mr. Percy has maps that he intends to touch on in his summary statement. When we draw the connections between statute and policy, we have the section 6A, obligation to recognise and provide for the preservation of natural character. Policy 13 NZCPS gives effect to this by requiring avoidance of adverse effects on outstanding natural character and avoidance of significant adverse effects on natural character. Section 6B RMA requires protection of ONL. Policy 15 NZCPS gives effect to this by requiring avoidance of adverse effects on outstanding natural landscapes or ONL. Section 6C RMA requires protection of the habitat of Indigenous species, and this is given effect via Policy 11 NZCPS, which requires avoidance of adverse effects on at-risk or threatened species and avoidance of adverse effects on the habitats, which include flight risks of flight routes or paths. When we look at the word avoid, the Supreme Court has confirmed that this means not to not allow or to prevent the occurrence of. Where there is a policy conflict, the obligation might turn to ensuring there's no material harm. The starting point in the Carrington Estate Zone provisions is to permit large-scale development based on the consents. The effects assessment underpinning the consents is now more than 25 years old. Over the passage of time, the natural environment has changed, law has evolved, knowledge quality, policy and approaches to effects assessments have advanced. There is no contemporary assessment of how the activities permitted by the proposed plan might affect natural character values, which are identified in 13.2 of the NZCPS and include things such as ecology, natural elements, processes, patterns, the darkness of the night sky, scenic or wild values, or experiential attributes such as smell and sound. Likewise, there is no present-day assessment of how those activities might affect ONL elements, which are also identified in the NZCPS Policy 15, subsection C, which include aesthetic, transient, cultural, spiritual, historical, and wild or scenic values. The same information gaps regarding the habitat of vulnerable species, inclusive of flight paths, exists. In our submission, it is implausible to suggest that 230 buildings up to 10 metres high, along with 113 additional accommodation units located in close proximity to natural character, ONL and sensitive habitats, would have no adverse effects on their respective values. Where effects are uncertain or poorly understood, Policy 3 NZCPS requires a precautionary approach, not permissive planning. It would be, we say, overly generous to claim assessments undertaken in 1999 provide sufficient assurance that the NZCPS avoid directives will be given effect. The lack of robust assessment of the permissive Carrington Estate Zone provisions, when tested against the NZCPS provisions within the current context, represent a significant gap in the proposed plan. This is inconsistent with the obligation to implement the NZCPS. Part 9 of the planning standards, of the submissions address the planning standards, which Mr. Percy covers in some detail. The key point we wish to make here is that dual regulation, inconsistencies and uncertainties, as identified by Mr. Percy, also manifest a risk of allowing development beyond what was originally approved by the consents. For instance, there are two separate paths to exercising rights to develop. The proposed plan provides rights to develop in accommodation in general accordance with the project plan, where the consents purportedly afford rights to develop in accord with the proposed plan. The dual framework, flexibility and unclear terminology blurs land use rights, undermines certainty and offers little confidence that the Carrington Estate's own provisions reflect council fulfilling its core functions. The final area to cover is at part 10 of the submissions, which address the section 32 report. The section 32 report primarily it compares the proposed plan to the existing one without, in our submission, critically assessing whether either is appropriate under current law and policy. In short, we say the report fails to meet the section 32 RMA requirements to assess whether the Carrington Estate zone provisions is the most appropriate method to achieve the RMA's purpose, to evaluate the scale or significance of likely environmental and cultural effects, and to consider information gaps or risks of acting without adequate information. Now, we do note that Kaitāia Marae made a request for any information the council might have as to how the Carrington Estate zone has been operating or performing, including any monitoring information. And the response received from council is that no such information exists. So that covers the key points that we have made in our submissions. Happy to cover questions now or to hand over to Phil and circle back to group questions afterwards.
Thank you very much. I think your legal submissions are sort of quite clear. I don't have any specific questions for you. I notice you have got a couple of attachments to those legal subs. Do you want us to take us through those attachments?
Attachment A?
Attachment A. Those are the official information stuff you just talked about. But just tell them.
Sorry, sir, what was the question?
Sorry, just want to take us through that attachment. That looks like it's a copy of your Lagoima request, is that right?
Yes, it is.
Okay.
Did you want to talk through the attachments there?
No, I just wanted to know, is it just there for information to us that you asked for information under Lagoima and have you received it?
No, the response from council was that no such information exists. The key point that Kaitāia Marae wishes to make is that we have a framework that's been sitting in place since 2003 without any real evaluation of the changes to the policy framework, without any monitoring of how the planning framework has been operating to date, and without any assessment of present day effects in cultural, ecological and in terms of the values of the various features, landscapes and character within the coastal environment.
No. Okay, so no, we don't have any further questions for you. So
Thank you. So we'll hand over to Mr. Percy.
Kia ora koutou. Can you hear me all right?
yes.
Great. Thank you. Yes, so my name's Philip Percy. You'll hopefully have my evidence in chief there and a set of track changes provisions.
Yes.
Great, thank you. So I'll just do a quick run through of what I covered in my evidence, key points, and then I expect it's probably most useful to the panel to ask questions and deal with things that way. So I'll give a quick overview now. The executive summary of my evidence provides an overview of what I think are the three key themes or planning themes that relate to this issue or this topic. The first one is how should the district plan interact with a set of existing resource consents that authorise development in the special purpose zone. In my view, there's an issue of regulatory duplication arising from the consents being essentially transposed into the district plan while those consents are still in effect. Those consents authorise the development of Carrington Estate, and as such, duplicate provisions that almost also permit the same development or minor adjustments to that development are not required in the district plan. If the consent holder wishes to amend the approved development, there are established processes under Section 127 of the Resource Management Act that allows the consent holder to apply to cancel or change consent conditions. Allowing for deviations to the consented activity by way of district plan provisions creates, I think, significant compliance complexity. As Ms. Ehrlich has just described, you potentially end up in a situation where the plan is authorising parallel or largely the same development as the consents are authorising, and it creates a degree of uncertainty as to which of those provisions or which mechanism is in play at any particular time, and how those two mechanisms interact. And by way of example, the majority of the buildings that are already established within the resort differ substantially both in location and design from what's shown on the development plan. And in my evidence, I included Appendix C, and you'll have to excuse my my rough GIS skills, but that approximately locates the existing buildings on the site in relation to the building footprints that are shown on the development plan. And so the green, if you turn to that appendix, the green or the light blue squares on that are what I've identified as buildings from an aerial photograph, and then I've overlaid the development plan on there. So the black squares within that document are what I understand to be the building footprints. And so it's and there's a similar issue there in terms of the design and cladding of the buildings. They appear to differ substantially from the development plan. That's most obvious when you look at some of the images on the Carrington Estate development plan. But if you're going to visit there as well, you'll see the design of the buildings, and it will be interesting to compare that to the development plan and the descriptions of cladding and appearance of the buildings in that development plan. It's not clear whether those changes have been authorised by rules in the operative plan, whether they are changes to conditions of consent, or whether they've been regarded as being in general accordance with the consents. And probably most obvious of those differences around buildings is in and close to the road, there are three or four, no, maybe five buildings or structures that aren't shown on the development plan. So it's possible there was a separate consent that was authorised for those. Mr. Wyeth may well be able to advise the panel on that, but yeah, that seems to be a significant deviation from from the development plan. The second issue is whether there's a need for and the appropriate extent of the special purpose zone as a planning mechanism. Large parts of the current special purpose zone are used in a manner that's consistent with the rural production zone. There's been no meaningful evaluation of whether that would be a more appropriate zone, that being a rural zone, a rural production zone, and management approach for the majority of the site. And that's not intended to be used for resorts or tourism activities. That's most obvious on the winery side of the road. There's a large area there that's in horticultural activity, vineyards and so forth. I included an image in Appendix A of my evidence that shows a relationship between the extent of the development shown on the development plan with the extent of the special purpose zone. The most obvious question in my mind is why such a large amount of land is required for the special purpose zone when no development is proposed there, at least in the development plan. I set out in my evidence the requirements of the national planning standards around the use of special purpose zones. I haven't seen any evidence to support the broad extent of the zone. I'm also unclear as to why a special purpose zone is required at all, given the existing resource consents and other planning layers that could be used instead. At the very least, I think there's an opportunity to refine the extent of the special purpose zone. I think there's definitely an opportunity to examine whether there's a more appropriate plan mechanism for dealing with development in that area. And the third main issue in my evidence is around the lack of clarity and certainty in the drafting of the provisions. The policies and rules are imprecise and inconsistent. They use undefined terms and reference a design guide and development plan document that is difficult to apply in the context of the rules. And I've set out a number of examples in my evidence of those. Especially where permitted activities are to be used, they should be certain and clear and enforceable. And the track changes provisions I've provided, I've recommended removing the permitted activity rules and the controlled activity rules and the associated standards. This goes a long way to resolving the drafting issues, obviously. If those rules are to be retained, if the panel decides to retain those rules or some form of them, I think there's significant work that's still required to improve the drafting to ensure they're fit for purpose. So in my view, the special purpose zone provisions can be resolved in the following ways. Remove those provisions of the special purpose zone that largely duplicate the existing resource consents. This will resolve the issue of the plan provisions and the resource consents both controlling the same activity, which is unnecessary in my view from a planning perspective. The owners of the Carrington estate will be able to undertake the proposed development in reliance on their resource consents. Any deviations or alteration or alternative development options can be guided by the district plan provisions that provide for consideration through resource consent processes. And then the other change I recommend would be to either remove the special purpose zoning from the entire site and use another plan mechanism, or reduce its extent so that it reflects the development footprint of the consented estate area. Doing so will resolve the issue of the district plan not giving effect to National Planning Standard 8.3, and it'll align the management framework in the district plan with the characteristics of the existing rural farming horticultural uses of that broader area. So I don't plan to go into any further detail. If it would be helpful, I could step you through the track changes that I've suggested. It's a relatively quick exercise in that I've recommended a number of deletions.
Yeah, thank you, Mr. Percy. I mean, certainly for me, I understand where you're coming from with regards to those track changes. So they sort of they follow on from what you've set out in your evidence, and particularly removing the permitted standards and
Making everything discretionary.
Yeah, that's right, making everything subject to a consent. That makes sense. I understand where you're coming from for that. Unless there's something else that's in those provisions that you'd particularly like to refer us to.
No, I don't think so. The only thing that it's a reasonably coarse attempt at redrafting to give effect to those recommendations in my evidence. I think there's potentially opportunity for a restricted activity status in there for some some limited deviation, but as I've said earlier, I think there's a fair bit of drafting effort that would be required to make that work and get some tight standards in place. So I haven't gone that far at this stage.
Yes, I think we appreciate that, as you say, it's a course level review of it. We do have a couple of questions for you, though. With regards to the national planning standards, and you've set out that criteria in 8.3 of the national planning standards. And you may or may not know that we've been down this road already with another zone in the proposed plan.
Right.
So reasonably familiar with those criteria, and they're quite strict. In your paragraph 51, you said it doesn't include any additional analysis as to whether CARSPZ satisfies standards. Have you formed a view as to whether it complies with those criteria? Or are you wanting to say it might do, but we haven't seen the analysis? Where have you landed on that?
I think the answer is probably yes on both counts, in that I don't think this, well, from what I've seen in terms of the Section 32 report and the Section 42A report, which largely cross-references to the Section 32 report, I don't think there's analysis in there as to how or if those criteria have been met. And then secondly, I don't think that the Carrington Estate Special Purpose Zone meets those criteria either.
Can you take us through which ones you don't think it meets? Can you take us through which ones you don't think it meets and for what reason, or is that a little bit more detail than you've gone into?
No, I'm happy to happy to talk through that. So that standard says an additional special purpose zone must only be created when the proposed land use activities or anticipated outcome of the additional zone meet the following criteria. So there's two things in there: the proposed land use activities or the anticipated outcomes. So whether they're significant to the district, region, or country, that's a matter for debate, I'm sure. And I'm not 100% sure with how broad that the significance, if you like, would apply. I would be surprised if there was a regional or a countrywide significance to the Carrington Estate Special Purpose Zone. There may be an argument that there's some benefit, or there's benefit at a district level, but it would seem that it's a largely a localized benefit. There's certainly be some tourism benefits and flow-on benefits there. Whether that's significant, I'm not sure. The key question, I think, is whether the zone, whether it's impractical to manage the land use activities or the outcomes through another zone. So as I said, there's the large area of land on the I'll call it the winery side of the road, that is largely in vineyard and rural uses and other uses that aren't actually part of the development plans. And the winery itself and the buildings that are proposed, development that's proposed around the winery, when you look at the development plan, is quite confined. It's around those buildings that are largely already there, albeit there's potential for some additional buildings to go in. So there's a large area of that land that I think could practically be managed through the rural zone. And I don't think it would be fair to say that it's impractical to manage that area at least through rural zoning. Similarly, on the resort side of the road, because those consents are already in place and the development that's set out is largely what's been authorised by consents, there's not a strong indication that there's any plan for significant deviation than what's allowed by those consents. An underlying rural zoning or alternative zone that's already available in the plan could still operate through that area with the consent sitting over top and enabling and managing the development. So it's not essential that you'd actually have to have a specific zone in there. I think you could also potentially operate or apply an overlay or some other lighter level of control rather than a zone itself, if there was an intention to trigger some particular policies that it might apply to resource consenting in that area.
Can I just inquire about that one? Because where we ended up in another case was considering whether a precinct was more appropriate, because that allows an underlying zoning to apply, but it provides particular spatial or place-based provisions to recognise an identified activity, which I suspect may include a resource consent. I mean, because I was going to ask you, have you considered other mechanisms? But I thought I might as well just throw that one at you, see whether you've considered that and whether you had any view on that as a method.
Yeah, I haven't. I mean, I've had a run through in my mind, I suppose, of what those alternatives are, and I think a precinct, using a precinct, could be a way to achieve that. Particularly, like I say, if it's around bringing particular policies to bear through a resource consent process, and I'm involved in other planning processes where precincts have been used or are being proposed to be used, which definitely provide for that that, I suppose, a finer grained or nuanced approach within an underlying zone. So yes, that may well be an alternative. I haven't gone into a whole lot of detail to fully test it out, but that would certainly seem to be one option on the table.
Okay, no, thank you. That's really helpful. So let you go back to the last criteria, which is C, impractical to be managed through a combination of spatial layers. Have you got a view on that one as well?
Yeah, well, I think that's I suppose similar to the to my thoughts on criteria B, in that there are already some spatial layers sitting over that area as already, the coastal environment layer, the some of the ONLs and ONFLs and so on, and using a precinct or an overlay, you could still achieve those same, I suppose, triggers or direction that the planning maps are intending to send the council down when it's considering a consent application. So I think you could certainly apply those sorts of things in that place as well. And I suppose there's, as I say, there is a question there as to how important, or how much a spatial layer or a zoning layer is actually required in that area, given that the development site is consented and authorised under the RMA. Does it actually need an additional spatial layer at all?
And so finally, I mean, you've talked about this this issue of where is it now? Duplication, regulatory duplication, because there's a resource consent there, and then there's a zone that appears, well, I think in your evidence, is replicating what the resource consent. But I suppose I'm just wondering, is another way to look at it though? Are the special zone provisions also a recognition of what has been lawfully established and what forms part of the existing environment?
But you could use a special purpose zone for dealing with that, and I think in a lot of cases, development of a particular area or a particular site, and I think I refer to the Kauri Cliffs, area as one of those developments that has established and there's intention to, grow or further develop that. So you could potentially use a special purpose zone, for something like that, where you've actually got a framework sitting in the plan. The plan itself is establishing the framework, it's establishing the master plan, it's got objectives and policies that are talking about where that development of that land should go, what those outcomes are, and so on. You could absolutely use it for that, and if that development was partially established historically through a resource consent, then then you could provide for that future development beyond that consent. But I think in this case, that hasn't, from what I can see, hasn't been signalled. The clear signal, as far as I can see in the commentary that I've read, is that the special purpose zone here really is about reinforcing the consented development. And I don't understand, I don't see what the planning, I suppose the planning benefit of, as I say, largely duplicating that authorisation through a planning zone achieves over and above what the resource consent's already authorised.
Okay, I haven't got any more questions, but I'll see whether the other commissioners do. Shall I go to?
Please.
No, give us.
No?
No, I think my question would be for the council planner rather than Mr. Percy, and maybe Mr. Sanson when he comes on board. But you've raised no duplication stuff.
Yeah. It looks like we were all on the same wavelength for questions, Mr. Percy. So it looks like we've got no further questions. So thank you very much for your thorough evidence and attendance today.
Thank you.
So we're back in your hands now, Mr. Poet.
Yeah. Ms. Ehrlich will refer you to a couple of maps for your fellow's site visit tomorrow, which set out the maps in the appendices of Mr. Paul, and I think it's also helpful to have the maps that are in Mr. Percy's evidence. But just in terms, before we get there, in terms of some of the questions that were asked, in terms of, so one of the key submissions that's being made is that it is for a plan to implement the higher order documents, not to implement consents. And that's the assertion, that's the perverse nature of this special purpose zone. If the issue is about confirming existing use rights, a plan is not the mechanism to do that. In fact, the framework provides for the application of existing use certificates to be applied for in section 139A. Those haven't been applied for, but that's where that occurs, rather than flipping the planning mechanisms on their head to try and get them to implement lower order documents. And I guess the other issue, and I think it's important to talk about, is those national planning standards that were discussed around these special purpose zones. I mean, where they tend to arise to ensure the provision of infrastructure. For instance, a port zone, an airport zone, those things. And I think 8.3a talks about either district, regional, or national significance. The important thing about 8.3 is that A, B, and C are ands, they're not alls.
Yeah, I understand.
So to get to those last two, it needs to have the, and regionally significant or district, I don't know, how do you say districtly significant? It's my English is failing me at the moment. Significant for the district doesn't mean expensive or big. It's infrastructurally significant such that the district requires it to function. And I think this is while it might be to the private investor or to the rates take something significant, but it doesn't seem to have that tenor. And for that reason, also the submission that I make is that the mechanism in itself is, it's not just inappropriate, it's kind of perverse in the way that it seeks to give effect to a resource consent instead of giving effect to something in a higher order document, and there's nothing in any higher order document that's been identified, or in part two, if there is uncertainty or a lacuna there, that allows that to happen. So those are the two issues that I'd add to the matters that have been traversed. I think Ms. Ehrlich was rather comprehensive in the submissions. There's a lot of detail, but I think it's important that the detail doesn't overshadow the key allegations that sit within the submission that reflect that the way in which this plan's been propounded are unlawful. So in terms of that, I'll hand to
I just want to ask you one question, because you've referred us to the special purpose zone being primarily for, as you say, infrastructure. And I'm thinking, well, if we apply that rationale to other special purpose zones in the district, and in particular, the one that we were discussing immediately prior to you, being Kauri Cliffs, just down the road, if we were to apply that same legal lens, would we have to rethink that special purpose zone as well?
In my submission, there does need to be a consistent approach across the district, and what because I wasn't aware of the zone around Waiawa until sitting here listening to it and reading the evidence that was helpfully circulated earlier. But how can that be said to be, in terms of 8.3, significant for the district? And I mean significant for the district as a whole. Now, it is not my place to make submissions on that, in particular off the top of my head, but if it fails for that, then necessarily, yes, that is the lens, the standards are set, and they need to be applied consistently across the district, implementing the way the rules are applied across the region, implementing the way in which the rules are applied are applied nationally. It can't be, it has to be perverse to go the other way around and then try and re-engineer it in a way that says, well, this doesn't really fit, but how can you then treat it like as if it was a port?
Okay, thank you. That's something to ponder.
So, do you have a response to my response that you would like to make?
I
feel free.
Want to, but I won't argue with you.
Sorry, Troy, if I could jump in.
Yes, you can.
One area or one spatial layer that might be worth considering, whether in this case, I'm not so sure, but across the plan, and I think the plan already uses it as a development area. And yeah, that's set out in the national planning standards as well, but that seems to be set up for those areas where you have a spatial plan or a development plan that's implemented, put in place, activated, and then that I suppose that development area evaporates out of the plan. the development's already been established and then it continues to operate. So that might be another matter to consider for the council.
You go. No.
Yeah. Okay. Does that now leave us with the matters to look at during the site visit?
Yes. Oh, sorry.
I've just been told that there may be one further question, two further. Okay, there's more questions.
I'm not sure if this, who will answer this question relating to infrastructure, because Kauri has a municipal sewage system, so the council wastewater system, and Carrington Estate is one of the key larger developments within that locality. I guess given the scale of what you've talked about, the resources, and then also talking about what Mr. Percy said is a duplicate process for the proposed special zone. Can you give comment about that, I guess, an anticipated connection onto council's wastewater system and how those existing consents or the proposed special zone influence and affect that? I'll be asking a similar question to the planner for Carrington Estate as well. You can hear me answering this question now.
Off the top of my head, that's really difficult. I mean, I guess if this was the consent for the wastewater treatment plant, then you could maybe look at it in that way. But I hear from you that you're asking me about how this particular historic consent interacts with a new wastewater treatment proposal. Yeah, I'm probably not in a position to answer those questions. I'm not sure if you are, Mr. Percy, given my lack of knowledge about that particular development. I'd probably just get everybody into trouble.
Yeah, I'm not 100% familiar either with how Carrington Estate intend to deal with their wastewater, if and when they grow. If the intention is to plug Carrington Estate into the council's wastewater network, and that's I suppose, and this is possibly where your question is going, if that influences the upgrade or development of the wastewater treatment plant. I'm not sure that the zoning makes a whole lot of difference. The council would be able to presumably, rate the Carrington resort based on its connection or its demand on that wastewater network or system. And the Carrington Estate development is already consented. It can proceed, as it stands. So, yeah, I'm not sure how much the zoning would interfere with any upgrade or development of the municipal system. But I might have got the wrong end of the stick of your question.
No, yeah, it's probably if you had knowledge of the previous issued consents, yeah, would relate to that. But maybe the planner for Carrington would have their historic knowledge, and we will direct the same question to him.
I do recall some years ago there was, and I'm not sure how far it went, but there was some consideration of on-site, wastewater, upgrading wastewater on-site at Carrington Estate, but I'm not sure whether that's happened or what's, where that's progressed. So it might be a question for Mr. Sanson.
Great, thank you.
I thought we're all good. That's our last, we don't have any more questions for you. So, site visit.
Go site visit.
Site visit. So Mr. Paul's evidence has an attachment B, which identifies Wairahoraho, Waimango and Karikari Moana.
Just to show. I don't know how good this is. I'll be van or white. So this is the first picture, and then
We can't see that. So look, we have his evidence here. You're going to attachment B of Mr. Paul's evidence, yes?
Yeah.
I should tuck my shirt into.
And there is.
Oh, that's you.
And Mr. Percy's evidence somewhere.
Attachment B, here.
So those are the three, in terms of his evidence, he locates three particular areas, Wairahoraho, Waimango and Karikari Moana.
Oh, yes.
And there's particular things.
Yeah, that's it. So these ones here. One, two. Yeah, I don't know where's the third one. This is just two.
Oh, no, there. These are three. Two. One is the.
Okay.
One.
Karikari Moana is the beach. It is the beach, but in terms of the coastal policy statement, standing on the beach, looking back, in terms of the matters that ought to be implemented in terms of the coastal policy statement.
And the connectivity for the freshwater.
Okay.
And I guess
Yeah, thank you.
Oh, sorry, sir.
I was just going to say, yes, we understand where those areas are, and we can include them on our site visit tomorrow.
Mm-hmm. The other area that might be useful to visit is the restaurant and vineyard area. It gives quite a nice overview to the catchment and the land that's within Carrington Estate. Mr. Percy has an Appendix A, which includes a zone and development plan layer.
But that didn't the winery on it.
Sorry?
I don't think that plan included the winery on it, on the other road.
We know what that is.
Yeah.
Do you know where it is? Did you have any other areas you'd suggest?
Yeah, I think the winery, up at the winery is a good place to see, see both sides of the road and up behind the winery as well.
I never knew encourage to visit a winery. If you think anything else you'd like us to pay attention to, feel free to send an email to Alicia Kate, before 5 o'clock today, and she can make that available to us.
and am I going to take it that there are no questions for Mr. Paul, that we when we do talk to him, that he doesn't have to expect a barrage of hard questions that we can put on the spot.
No barrage or any questions at all. I think it's self-explanatory.
Thank you so much.
Okay, thank you. There might be something that may come out of that. There might be something that may arise out of our site visits, but we'll make that probably a direction towards that happens.
Mm-hmm.
All good. Well,
thank you so much for your presentation and evidence and answer to our questions today.
Thank you very much.
Kia ora. Thank you.
Samson, do you want to come and sit up here in the opposite? Alicia Kate might take a bit of the sun off you there.
I think it's the other one better.
Yeah, that's good.
Here as well. So you are breaking at 3, which we can just.
Yeah, we'll see how far we get.
Okay.
We will, if we're close, we'll just keep going for a bit.
Yeah, you're all right.
I know. Are you going to be, are you going to have legal?
Yeah, Olivia's,
submissions as well? Okay.
she'll go first on the batting.
Good afternoon. Yes, hopefully you can see and hear me on the screen.
Yeah, but you're very small.
Hang
We're
on,
going
I'm
to
just
make you a little bit larger.
Are you sure that's necessary?
Um,
I don't mind being small.
it's quite a small screen, so worry. Okay, yes, so good morning. We can see and hear you, and you can see us, I hope.
Yes, I can. Thank you very much. Oh, good afternoon, and thank you very much for accommodating me online. My name's Olivia Pahulu, and I'm appearing as counsel for Carrington today in respect of its submission on the Carrington Estate Zone. I understood from your comments to Mr. Poe that you have read legal submissions received on Friday. So I'm in your hands as to whether you'd like me to read my legal submissions or really just speak to them and answer your questions.
Thank you.
Look, they appear to be reasonably short.
They
so
are.
we're for you to take us through them. Free to paraphrase where you think things could be taken as read. How's that?
Yes, that sounds perfect. Whatever is of most assistance to you. Just as a preliminary comment then, I would just note an error on my part, and I'd like to clarify it lest there be any question as to standing. Mr. Sanson's evidence correctly refers to evidence and submission being on behalf of Carrington Estate JDLP and Carrington Farms JDLP. My legal submissions say Carrington Resort JDLP. That is incorrect. It should be Carrington Estate JDLP and Carrington Farms JDLP. So just to clarify that from the outset.
We don't have any issue with that.
No, thank you for confirming, but I just wanted to make sure the record was clear. So if I may begin, as I just mentioned, I will refer to them collectively as Carrington as well and do my best not to confuse everyone with reference to Carrington as the submitter, Carrington Estate being the development on the Kauri Peninsula of which Carrington manages and operates, and the Carrington Estate Zone, which is the planning chapter that we're here to discuss today. So Carrington have lodged a submission and further submission in respect of the Carrington Estate Zone, as was helpfully summarised by counsel for Hai Te Tai Marangai Marae Kaitiaki Trust. This chapter originated from resource consents that were granted back in the late 1990s and were subsequently incorporated into what is now the operative district plan. They were first introduced or proposed to be introduced in 2003, and I just note Mr. Sanson's evidence that the operative district plan became fully operative in 2009. In Carrington's submission on the proposed Carrington Estate Zone, just to summarise its position, it's generally supported the Carrington Estate Zone as notified, sought application of some other specific zonings which it no longer intends to pursue, so just to confirm Mr. Sanson's evidence on that point, and sought some additional amendments to the provisions of the CEZ, one of which being the allowing primary production activities within the zone, which the section 42A has recommended accepting in part by introducing a new rule permitting farming activities, which Carrington supports, and including a new rule to carry over an existing rule in the operative Carrington Estate Zone, which provides for access, parking and loading within, in accordance with the Carrington Estate Development Plan and Schedule, or alternatively providing exemption in the relevant transport chapter, and I'll address that a bit further in my submissions. And similarly, a rule to carry over an existing rule in the Carrington Estate Zone to allow earthworks and vegetation removal in general accordance with the development plan as well, which the section 42A also recommends rejecting. I will just move to, and then yes, as I've mentioned, Mr. Sanson's provided planning evidence and he is also here today to assist and answer any questions you have relevant to planning matters. as I've just summarised, so Carrington owns land at Whatuwhiwhi in Karikari Peninsula, known as the Carrington Estate, comprising the resort, the winery and the country club. Has been largely developed in accordance with resource consents granted, I apologise, in the early 1990s, being a land use consent to establish, operate, maintain a vineyard and winery, which includes viticulture, a commercial winery and cellar, and a licensed restaurant and accommodation components. A land use consent to establish, operate, and maintain a country club and associated facilities, which includes the golf course and practice range, lodge, and ancillary activities, including function and conference buildings, and again, different accommodation components, and a related subdivision consent. As mentioned, they were first integrated in 2003 into the district plan, which became fully operative in 2009. This has been provided for in a specific chapter at the moment called the Special Purpose Carrington Estate Zone as a special area, and as mentioned by the Council in Section 42A, provides for special areas which take a similar approach of providing bespoke planning framework for typically unique, that should probably say, or large-scale developments. I understand that there are a range of special areas in the operative district plan which comprise a wide variety of particular developments or activities being undertaken in the Whanau district. Carrington largely supports the retention of the Carrington Estate Zone, which, as mentioned in the Section 32 report, is largely consistent with the operative planning framework in the existing Carrington Estate Zone, with some amendments to give effect to the national planning standards and achieve consistency across the proposed district plan. I then cover the statutory planning framework relevant to the proposed district plan and the Carrington Estate Zone specifically, and I don't propose to take you through that beyond just mentioning that the proposed district plan has been prepared in accordance with Schedule 1, and Carrington largely supports that process and assessment. Also just commenting on the national planning standards, which have been the subject of discussion today, and also just a mention specifically of the national policy statement for urban development, as this is relevant to a point of relief that Carrington has sought and which I will clarify further shortly. Moving to paragraph 22 of my legal submissions, which considers whether or not the Carrington Estate Zone is consistent with national planning standard direction on special purpose zones. And this was a discussion you've just had with Mr. Poe, Ms. Ehrlich, and Mr. Percy just now, particularly on whether or not the Carrington Estate Zone satisfies those criteria as set out at clause 8.3. There's some discussion around whether or not Carrington was significant to the district, region, or country. I would broadly agree with Mr. Poe's comments that there's probably a question as to whether it's regionally or nationally significant, but whether it's districtly significant. His comment there was that that does not necessarily mean that it's expensive or big, and I agree with that. That does not, and I don't read 8.3 as limiting significant to being expensive or big or large scale, but rather speaks to the functional role that it provides in the district. It's probably more of a matter for the council to consider and address as to whether they consider it to be significant, but I would just comment that Carrington is a significant and large scale development and comprises a variety and range of integrated activities forming the basis of a significant tourism facility and destination in the region, or well, in the district, and on that basis could be considered to be significant, and in my submission does satisfy that first limb of the clause 8.3 criteria. And Carrington supports the Section 42A assessment and Section 32 assessment that the zone and the development in the area are otherwise impracticable to be managed through another zone or through a combination of spatial layers. In Carrington's submission, it's appropriate that the Carrington Estate being the development and anticipated development that it is, has bespoke provisions contained in a cohesive and clear planning framework incorporating specific development controls for activities assessed as appropriate for the zone, which provides certainty and clarity for Carrington, but also for other plan users as to what can be undertaken in that zone. Moving to paragraph 27. We submit that that rationale is relevant also in the context of submission seeking deletion of references to the development plan and schedule. We submit that that is the specific document which provides the certainty on the anticipated and assessed outcomes for the Carrington estate. A note at 28 that a similar approach has been taken for other special areas currently recognised in the ODP. And just to note that I have used the example of Moturoa Island zone there, but on reflection over the weekend and in preparation, probably not the best example that I could have chosen to refer to at that paragraph. And so in addition to that one, and the rationale for using that one was that it has an associated development plan which guides development and land use activities in that zone. But perhaps a more relevant and analogous example would be Quail Ridge, which is provided for as a special area in the operative district plan, but which I note is also proposed to be retained in the proposed district plan as a special purpose zone, which is intended to enable a large scale, I believe it's a retirement village, so comprising multiple residential units, which is probably more akin to not exactly analogous, but where Carrington includes land use activities that comprise accommodation is probably more of a direct reference point. So my point there being that Carrington Estate is not an isolated or unique example in terms of special areas being provided for and recognised in the district plan, but there are others, and a similar approach has been taken for other similar special purpose zones. Turning now to the additional relief that Carrington is continuing to seek. First of all, turning to access, parking and loading requirements. It's noted that Section 42A did not accept this submission point and has recommended deleting Table 1 of the development plan and schedule in order to be consistent with the requirements of the MPSUD, which requires removal of minimum car parking requirements. Mr. Sanson can talk to this further as well, but just to confirm that it's agreed that that is what the MPSUD requires and that it applies in this context, and as such, it's agreed and supported that deletion of that Table 1 would be appropriate. However, Carrington submits that it is still appropriate to have a corresponding rule to reflect existing rule, I think it's 18.6.6.1.7, to enable and direct park or access and loading to reflect what is provided for in the development plan. And then just to further comment on that, consequentially, were a rule to be incorporated into the proposed district plan to reflect that existing rule, necessary amendments would need to be made to delete references to Table 1. It's submitted that this is appropriate because applying district-wide rules in relation to access and loading will not necessarily enable the objective 1 for the Carrington Estate Zone to be achieved, which is for land use and subdivision to be undertaken in general accordance with the development plan, as the development plan does provide particular layouts for access, loading and parking, and that is what is intended to be retained through incorporating a rule that reflects this existing rule. And then turning to paragraph 32 in respect of earthworks and vegetation clearance, the same submission point is intended to be made, which is that applying district-wide earthworks and vegetation removals may have an adverse effect of not enabling development and land use activities to be undertaken in accordance with the development plan. And as such, as paragraph 34, I submit that retention of those existing rules relating to access, parking and loading with necessary amendments to delete reference to Table 1 and accompanying deletion of Table 1 in the development plan, and a rule for earthworks and vegetation removal should be retained in the district plan to ensure that Objective 1 can be achieved. And then turning now to 35. Carrington supports the council's section 32 and 42A evaluations and reports, and as noted, is generally in support of retention of the Carrington Estate Zone, except as otherwise just addressed. And turning now to 37, where I comment on duplication of the resource consents and High Court and the relevance of the High Court appeal. Let's turn to some comments that Miss Ehrlich made earlier. As she noted, both Kaitāia Marangai Marae Kaitiaki Trust and Carrington are generally agreed that the outcome of the High Court appeal is not relevant to the assessment and determination of the appropriate provisions for the Carrington Estate Zone in the proposed district plan. However, I did just want to comment that Ms. Ehrlich noted that my legal submissions suggest that there's no relationship between the resource consents and the plan provisions. And I did not intend to make that point, and definitely do not read my legal submissions as making that point. I think what I would like to clarify is that it's clear that the resource consents were the original premise and the original basis for the drafting and subsequent incorporation of the Carrington Estate Zone into the Far North District Plan. So there is absolutely a relationship between the two. However, following introduction and incorporation of the Carrington Estate Zone into the district plan, particularly once fully operative, my submission is that it then exists as a separate planning framework to the resource consent. So while they are related, and the intention as set out in the overview to the Carrington Estate Zone is that it's intended to be developed within a framework reflecting the resource consents previously approved. My submission is that they do remain separate planning mechanisms. On the one hand, we have the resource consents, which are the subject of a High Court appeal, and as Ms. Ehrlich did mention and comment on, and which I agree with, that proceeding is focused on the status of the resource consents and does not concern proposed plan provisions. And secondly, that the district plan then operates as a separate planning mechanism to the resource consents. I think that covers everything I covered in my legal submissions, certainly by way of paraphrasing, probably more than direct reading, so I hope that that was clear, but happy to answer any questions arising from that.
Questions? I think probably. I've got the feeling that we should probably get into the planning evidence, and then I suspect there may be answers that may be better directed to you. Are you happy for us to proceed?
Yeah.
Yes. Like that?
Yes, I was going to suggest perhaps if Mr. Sanson speaks to his planning evidence, and then absolutely if you would like to direct questions to us both to answer as we consider to be most helpful, happy to proceed on that in that manner.
Great, thank you. Well, good morning.
Good morning.
Absolutely.
It's been a long morning.
Yeah, it has.
Welcome back.
Yeah.
We've read your evidence. So do you have a summary to give us, or do you want to just take us through?
Yeah, I'm happy.
Do you want to go jumping straight into questions? We're in your hands.
Yeah, I'm happy to just give a pretty brief summary because I do need to clarify the parking aspect that Olivia was just talking about.
Yeah.
So I'll take my medicine. We do have to delete the parking amounts from the development plan, but I guess the importance is that the locations of the access ways, relevant to Matai Bay Road, are described and shown on the development plan. So the intention is that whilst, the parking numbers
Seems to us we don't have any discretion. That's a pretty clear direction. Yeah. But what I was thinking when I was reading that, and I went back and had a look at the NPSU there, and it's pretty direct.
Yeah.
There's nothing to stop the estate requiring car parking.
No, that's right.
For its own members. There's a way it manages its own tourism resource. There's nothing to stop you showing car parks and ensuring that that minimum number is established.
Yeah.
In order to, and I think that's one of the angles that the NPSUD sort of comes from, which is car parking is a market mechanism.
Yeah.
If you think you can run your activity without providing car parking, and you think that business will be successful, then you can.
Yeah.
But I think what you're saying is that this tourism activity needs to have car parks to meet the client's expectations, the users, and so you're going to provide them.
Yeah.
And in terms of earthworks, I guess, again, linking back, earthworks and vegetation clearance, linking back to essentially what the ODP rule was. And that doesn't come with, that isn't, I guess, unlimited there. You'd still have sort of wider regional council requirements as well, so they're just permitted under the FNDC consents. Just reflecting on perhaps the statements from the previous evidence around linkages to fresh waterways and vegetation clearance and the impacts of that. So it's not saying it's a broad brush. Actually, there are limitations already under different planning regimes. I think that's sort of more or less it. My evidence, I do agree a lot with the 42A report in terms of bringing across a large range of the ODP provisions, and mine are really, I wouldn't suggest them as sort of fatal flaws as Mr. Percy does, but as rejigs to ensure that they're, how the ODP was intended is carried across into the PDP, and how the development plan is reflected moving forward. So I've got a ton of, I think, questions that you'll probably ask me and potential answers, but yeah.
I was going to say, have you got any comment on the National Planning Standard evidence that Mr. Percy sort of clarified for us today, and he went through the reasons why he thinks it doesn't meet 8.3 of the National Planning. Do you have any? Yeah, I mean, I
had them up before.
Yeah.
1 second.
I'm just wondering whether you've got any planning response
to our significant. I guess with my planning hat on, up to 200 plus units. In my experience working up here is a significant type of development in the far north. So that's how I would, I guess, give feedback against A. B is impractical to be managed through another zone. So I guess Mr. Percy and yourselves have been teasing out this thought of a rural production zone or a mixture of zones. But to me, the extent and the coverage of the Carrington Estate Zone provides the protection not only of the development itself, but it gives it a wider buffer in the wider environment. So if you were to cut it up into these multiple zones, precincts or development areas, I think you actually lose the intent of an approved development area, as well as providing a massive buffer around it. And I think there's a lot of implications of split zoning or multiple zones, because if it was rural production zone, for example, even if it's just a winery, I mean, we can do a lot of permitted activities under that as well that might not be considered by other parties. So, I just think, we're providing as much certainty as possible because we've got an approved development plan. We know the spatial extent of that development. And I guess the criticism from previous respondents is that, but we've got all these developments, in general accordance. We don't know if it's going to be 5 metres away or 10 metres away, but I guess what we do know is that it's, development's not taking place in the wider zone itself, because the development is quite, it could be better defined. I will agree with that. But what I'm saying is with what we've got, it can be quite clear that, hey, we're not going to do the 230 units next to the, I saw some maps from Mr. Percy, those key cultural areas. So that's what I just mentioned about B. I think that's B and C together, to be honest. I think we'd get more confused by having a split, and in that case, if you've got two different zones, could Carrington or someone else carve out the development site and then not be the owners of the other site? There are things like that, and then you could have differing types of activities that aren't consistent with this aspiration and image of an entire country club and golf course estate.
So, and again, the question I put to Mr. Percy, if we were minded to accept that there is an issue with the New Zealand standards, planning standards, do you have a view as to whether it could be established as a precinct with an underlying rural zone?
Oh, I've been trying to do a precinct for another task, and that's a high bar as well. So, like, I don't at this stage, I guess, have a firm view of what the combination of layers or the zone itself might be if there's this broader test or legal argument that, like, not just Carrington but a range of others don't pass it.
Yeah, I think Mr. Percy said that that the actual country club and resort could have an underlying rural zoning because you could rely on your resource consent. But that's a pretty rigid proposition, isn't it?
Yeah. And just from my perspective, it's like, well, planning to planning, we both agree, well, you can give effect to the consents, but then there's this wider legal question, I guess, happening. So it's all.
You'd have a country club that's got tourism as its purpose.
Yeah.
Trying to justify itself in the context of providing for rural production activities.
That's right. Yeah.
But I'm not sure whether that solves the problem or actually makes it worse. Okay. Those are my key questions for you, was the planning standards and the car parking. We'll just see what the other commissioners have got for you.
Thanks, Steve and Olivia. So Mr. Percy had flagged, there's this reliant on the resource consents that have been, done back in the late 1990s. And he had flagged that, a 127 allows a deviation of the consent, and your deviation isn't significant because if it's way beyond what was granted, then you have a consent. And he made mention of claddings differ, and he's not sure how that's happened. And he said there was another deviation from the development plan, and then the comment was made that the council planner might know. But the council planner said, let's ask the Carrington estate planner. Yeah. Have there been other deviations?
Oh, One, I think, let's just go to the 127 aspect.
Yes.
That's on the basis that there's a change proposed, right? So for all intents and purposes, the development plan lodged is what's going to be built, right? And that's why it's ingrained. I guess the next questions are, I guess what you're saying is provide an entire history and development timeline or history of the Carrington estate, and that's we haven't done that. To highlight to you what sort of deviations are, whether we use the black cladding instead of a blue one. I guess what we've relied upon time to time is that building consents are lodged, planning assessments are made. There'll be in the property file there'll be a wide range of consents, and the deviations are either permitted under would be permitted under the ODP. And if there's a significant deviation, then there should be a consent for that.
So also, this was granted 1999, I think I saw something on the plans. So do you consider the original consent conditions, set 26 years ago, are still fit for purpose today? And if so, why?
For the consent, yes, because that's what the approved consent says.
26 years ago, yeah. Just with changing times, changing technologies, changing methods, I suppose. Yeah, that was sort of my...
Yeah.
At a time when it was planned in 1999 to a time of 26 years later, that was sort of asking that question, did you see it was fit for purpose?
In terms of the consent, yes. Yeah.
Okay, so one more question, sorry. Why is the development plan still the best tool for guiding future development? and what risks would arise if this was replaced by district-wide rules. So you made some mentions about earthworks and stuff like that. Those would be applicable.
Because it's an approved plan, and then there's been a consideration of it.
Yeah. Okay. Yep.
Could I just speak a little further to that, if that's okay?
Sure.
I don't want to step on your toes there. Sorry, Steve. Just to say further that a lot of the development that has been envisaged by both the resource consents and the subsequent Carrington Estate Zone has been undertaken. And so to the extent that that tool is still the most appropriate, despite any deviations as mentioned by Mr. Percy, that is what still sets the guidelines for the development as assessed and consented and then incorporated into the plan. So to the extent that further activity is going to be undertaken, it is intended that it would be in accordance or general accordance with that development plan. So it just creates that certainty, that clear direction at a plan level. And then to the extent that any activity was proposed to be undertaken that was not in accordance with the development plan, then there are obviously those rules, the rules in the Carrington Estate Zone then set the relevant activity status whether an additional land use or activity is intended to be undertaken, and that would then enable a further assessment of that activity as distinct from the activities assessed initially in the resource consents, which then form the basis for the plan.
Thank you.
Thank you.
My question, I did sort of highlight, I was going to ask it relating to the council municipal wastewater system.
Yep.
And how that relates to the historic consents.
Yep.
And obviously is significant as a entity connecting into council's municipal supply.
So the estate's not within the area of benefit.
Correct.
So it's a fully self-sufficient arrangement for on-site servicing of the three waters.
And so there was no request from council either, going forward to connect, because I do historically remember that there was a conversation around that in previous years.
Separate development to the CEZ zone, Carrington Estate Zone. Yeah.
Okay, it was a separate development.
Yeah, separate development. Yeah.
And my last question was just around that. The earthworks and vegetation clearance. So council's the planner has recommended to not support the vegetation clearance and earthworks to be continued over into into this proposed plan. You obviously are seeking to retain it in accordance with the development plan. Do you have any response about if it was to be not carried over? As per what the council recommended?
Yes, so that would then mean that for the zone, I think for earthworks is 200 or 250 cubed for the entire development and across a very small area. So I just don't think that relates to the works that are required and that have been approved. And I guess on top of that, I said earlier, there'd be regional council oversight as well in that. So I guess I'm not saying that it's, what's the difference between the two? That is, I guess, from the FNDC saying, well, we can just do it just as long as it's undertaken according to the development plan. But I think it would limit us quite a bit, Carrington, sorry, if they were to undertake it to get consents for earthworks.